Well, tech companies are watching closely as the Supreme Court hears arguments in a case which sees Microsoft challenging a longstanding data protection policy. One America's Matthew Black has more on the case of Microsoft versus the United States.
The Supreme Court heard arguments on Tuesday for the first time in Microsoft versus the United States. The case promises to address the pressing issue of what information tech companies are obligated to share with law enforcement without violating customer privacy agreements.
At Microsoft, we filed this case over 4 years ago in 2013. And the day we filed it, we said that we were prepared to take this case all the way to the Supreme Court if that's what it took to protect the privacy of our customers around the world.
Back then, federal authorities subpoenaed Microsoft for information in connection with a drug trafficking case, citing a 1986 law requiring internet providers to share data with law enforcement. But since the sought-after information was contained in Ireland, Microsoft refused to provide the data, citing a breach of the Search and Seizure Clause in the Fourth Amendment of the Constitution.
And what this morning has further made clear is that we need 21st century laws to protect 21st century technology. This case is fundamentally about a law that was passed across the street in Congress in 1986. It is a law that was never intended to reach around the world or into our data center in Ireland.
Though Microsoft's president, Brad Smith, was optimistic after a day of opening arguments, reports suggest the judges were more receptive to arguments made by prosecutor Michael Dreeben, and justices even suggested that Microsoft could become a haven for criminals who are protected under their privacy laws. Dreeben also argued that the court had to decide the case based on the 1986 Stored Communications Act because it is the only law in place that governs these issues. That's why Microsoft is pushing Congress to introduce legislation to solve the problem, and efforts on Capitol Hill are already underway as a bipartisan group led by Republican Senator Orrin Hatch and Democrat Chris Coons are working to pass what is now called the Cloud Act.
The rise of email and cloud computing has put our data privacy laws on a collision course with the privacy laws of other countries. And it causes problems for email and cloud computing providers because they find themselves caught between orders by U.S. law enforcement to disclose data in other countries and laws in those other countries that may forbid such disclosure.
The Cloud Act has popular support in and out of Congress because it is said to maintain customer privacy, respect the laws of foreign governments, and enable law enforcement to go after information necessary for investigations. With legislation poised to hit the Senate floor soon and Microsoft's case before the Supreme Court, it's a race to see which branch of the government will decide the future of cloud data protection. Matthew Black, One America News.
We can use your help. Call your cable provider and kindly demand that One America News is added to your lineup. Call today.